Master of Ceremony will start the lecture. Actually.
Yeah. Okay.
Okay, we can start the class, Prof. Enjoy your
Yeah.
time. Okay, Daniel. Let's begin our occasion.
Ladies and gentlemen, we're about to begin, so please have a seat, turn on your cameras, and make yourself comfortable. Good morning, ladies and gentlemen. My name is Daniel Kando, and I will be your host for today. To the Honorable Dr. Tri Laksmi Indreswari, SMH, as Vice Dean of Faculty of Law, Universitas Diponegoro. To the Honorable, our visiting lecturer, Professor Dr. Thomas Schmitz, from the Faculty of Law, Universitas Göttingen, and also a DAD lecturer here in the Faculty of Law, Universitas Gadjah Mada. A very warm welcome we bid to all of the participants, the students of the Faculty of Law, Universitas Diponegoro. I would like to express our heartfelt gratitude for your presence in this memorable occasion. It is indeed a pleasure to have you here all today. We would also like to thank God for his blessings so that this morning we could gather here in this general lecture regarding freedom of religion and tolerance in a pluralistic society. Before we begin, please allow me to read the agenda of the session this morning. First, we will hear a welcoming speech from Dr. Tri Laksmi Indreswari as Vice Dean of Faculty of Law. And second, the lecture will be opened and guided by the moderator, Mr. Dias Tama. And third, there will be the presentation delivered by our guest lecturer. And finally, there will be, at the end of the session, there will be a question and answer session and also a brief photo session. Ladies and gentlemen, without further ado, we will now listen to the welcoming speech delivered by the Vice Dean of Faculty of Law, Universitas Diponegoro, Dr. Tri Laksmi Indreswari, SIMH. The time is yours.
Yeah, okay. To the Honorable Professor Dr. Thomas Schmitz, Professor of Law in Universitas Göttingen, German, also DAD lecturer in Faculty of Law, Universitas Gadjah Mada, student lecturers and all participants, good morning. It's my great pleasure to be here at visiting lecture, even in virtual, with all of you. On behalf of Faculty of Law, Universitas Diponegoro, I would like to say welcome to our guest lecturer today, Professor Dr. Thomas Schmitz. Welcome, Prof. We would say thank you to Professor Dr. Thomas Schmitz, who kindly accept our invitation. We do hope you can visit us, Faculty of Law, Universitas Diponegoro in Semarang, Prof. Today's topic is freedom of religion and tolerance in a pluralistic society. As we know that Indonesia is well known as a country with diverse ethnicity, religions, and race. So I think this is an interesting topic for visiting lecture today. This visiting lecture intends to develop our students' knowledge. We do hope we can maintain a good relationship between Universitas Göttingen, Germany, Professor Dr. Thomas Schmitz, and Faculty of Law, Universitas Diponegoro continuously. To all participants, thank you for joining this program today. Enjoy the visiting lecture. Thank you.
Thank you very much for the welcoming speech. Ladies and gentlemen, before we start the session, I would like to introduce our moderator for this morning. Our moderator is Mr. Dias Tama Anggita Ramadan, SA LLM. He received his bachelor's degree in Universitas 11 Maret, Surakarta, and his master's degree in human rights law in Cardiff University, United Kingdom. Currently, Mr. Dias Tama is a lecturer here at the Faculty of Law, teaching constitutional law. Mr. Dias, the platform is yours.
Okay, thank you, Daniel. And so, good morning, Professor Thomas.
Good morning. Selamat pagi.
Okay, so before we start, I will read your short profile. Here we have Professor Thomas Schmitz, expert on European law, constitutional law, and administrative law from Göttingen University, Germany. Currently, he is teaching at Universitas Gadjah Mada, Fakultas Hukum Universitas Gadjah Mada as DAAD lecturer at Universitas Gadjah Mada since 2018. And his areas of expertise, as I mentioned before, the European law, the constitutional law, administrative law, comparison of law in the field of public law, and legal terminology and multilingual communication in European and public law. And this morning, Professor Thomas, he will deliver his speech regarding the freedom of religion from Indonesia and Germany perspective. So without further ado, Professor Thomas, the time is yours.
Yes, thank you very much. I am very glad to have the possibility to give a guest lecture in your program. I'm very sorry that I cannot come in person. I would, of course, prefer to visit you at the campus on Universitas Diponegoro, but I hope that may be possible after the pandemic. It may be possible soon, I hope. So, ladies and gentlemen, I would first like to ask you to make sure that you have downloaded my materials, and I will show you these materials. Just a moment. Just no, there is. Yeah, it's better if you can now see the materials, right? On the screen, that's correct?
Yes, it's clear,
Okay.
Professor Thomas.
So I would invite you to download these materials because there are some information, like here the text of the relevant article in the German Constitution, which you may need to look up at these materials. Usually I would distribute them on paper so that you have them. The best would be if you can print them out and have them at your desk during the lecture. Also, I would like to explain that in my materials, there are some passages like here, which are underlined. If you click on these passages, there are links to other sources. So my materials also include a lot of links to more resources about the topic, which may be interesting. Well, I show you here the address where you can download Thomas Schmitz Yogyakarta ID. So everybody should download these materials. I will talk about freedom of religion and tolerance in a pluralistic society. This is the very topic issue all over the world now. I will illustrate that by the example of Germany, because I need to talk about one country. But Germany is also representative for the European perspective. Most of that, what I will say today, applies in the same way to almost all member states of the European Union. That means at least to 25 to 27 European member states, Union member states. In detail, however, there are differences. Development, globalization, and migration have changed the societies of many countries in the last decades. There is more awareness of diversity. New lifestyles and philosophies of life have developed. Cultures of different origins are mixed, and religions, which were previously insignificant in the country, like Islam in Europe, have become more important now. In Europe, there has been in particular a rise of Islam. 30 years ago, Islam was not important at all in Europe. Now, there are parts of the population which are Muslims. So it's part of the European society now. On the other hand, resistance has evolved from less flexible parts of the population who insist on the mandatory, homogeneous, traditional orientation of the society. These old thinking people who say, we want to stay and we want everybody to stay with our old traditions. We have that everywhere in the world. This raises the question of freedom of religion. as a constitutional fundamental right, a human right, of its scope of protection and its limits, of the role of religion and tolerance in the pluralistic society. My lecture will discuss it from the constitutional perspective, not the political perspective, illustrated by the example of the German constitutional law. Why Germany? Well, first we need to focus on one state because the constitutional approaches differ from state to state, in detail even within the European Union. German constitutional law provides a strong protection of the freedom of religion. Also, due to the rich jurisprudence of the German Federal Constitutional Court. This is the model constitutional court, which was the model for introducing a constitutional court in Indonesia. This rich jurisprudence on all aspects of fundamental rights, of human rights, is interesting for the topic. Human rights doctrine, fundamental rights doctrine, as we call it in Europe, is particularly sophisticated and comprehensive in Germany. There is probably no country with a more developed jurisprudence and doctrine on constitutionally anchored human rights, we call them fundamental rights in Europe, than in Germany and some other countries like Italy, Switzerland, and so on. Pluralism is a key feature in a society which is free and democratic. It is an inevitable consequence of any sincere commitment to human rights, since diversity combined with freedom always leads to a parallelism of different, sometimes even contrary, ideologies, philosophies of life, religions, and ways of life. You can see that in Indonesia too. When you go to Jakarta, the society is totally different than in the rather provincial Yogyakarta. And you have all kinds of lifestyle. Citizens with very different attitudes, mindsets, and morals need to live together in the same building or neighborhood, learn together at the same school or university, work together in the same office, and even belong to the same family. Therefore, in a free and democratic state, any assault on pluralism is an attack on the society. Tolerance is a key requirement of the functioning of any pluralistic society. Without it, tensions will rise and the society will break. The recent developments in the USA illustrate how quickly even a country with a long democratic tradition can be torn apart. Therefore, tolerance is a key obligation of every citizen in any free and democratic state. Strictly speaking, it is an ethical obligation, not a legal obligation. Real tolerance means to be willing to suffer. That comes from the Latin word tollere, to suffer, from the wrong behavior of others, but still to mentally respect and support their freedom. The classical doctrine is, I hate what you are saying and thinking, but I will fight for your freedom to say it and to think like that. The law, however, can only require the citizen to refrain from interfering action, for example, from violence or from discrimination on illegitimate, intolerant grounds. Like other EU member states, Germany is not a Christian state, but it's not a state with a Christian value system. Germany is only strongly influenced by its Christian history. This is important to understand Europe. Often here in Indonesia, I hear about the Christian European states. There are only very few. There's just Ireland, maybe, if at all. Today, only about 60% of the German citizens belong to the Christian churches. Germany's values are those of the free and democratic constitutional state based on the rule of law, namely human dignity and human rights, democracy, rule of law, and social solidarity, justice, and coherence, what we call the principle of the social state. These German and European values trace back to the philosophy of the Enlightenment and partly had to be forced through against the church's resistance. They are anchored in the basic law in Article 1 and 20, but nowadays they find their best formulation in the European Fundamental Value Clause. This is the credo of the free and democratic state, which you find in Article 2 of the Treaty on the European Union. I have printed it in my materials, so you can read it. These are the common European values, and they are the same as the German ones. Now let's come to freedom of religion as a fundamental right. Well, historically, it is the answer to the long-standing struggle between the Christian denominations, the Catholics and the Protestants. Previously, according to the principle cuius regio, eius religio, which means me, the prince, the monarch, dictate your religion, the prince determined the denomination of his subjects, and religious minorities had no other option than to emigrate. Tolerance was never a characteristic of the Christian civilization. In Europe, you know who has brought tolerance first? Who has granted first tolerance in Europe? It was the Muslims. It was, in fact, during the era of the Moorish Muslim rule in Andalusia, in southern Spain. So the first time that somebody granted tolerance in Europe was the Muslims who were having their empires in the southern Spain, the Moor. Nowadays, freedom of religion and the freedom of philosophical and ideological creed, this means a Weltanschauung, this means non-religious worldviews, they form two very close fundamental rights, which are anchored in Article 4 of our basic law. Some aspects are concretized by Article 136 of the Weimar Constitution, an older constitution. These articles have been incorporated into the basic law, our present constitution. I have printed these articles on the materials. The fundamental right of freedom of religion is complemented by the German constitutional law on state-church relations, the Staatskirchenrecht. This law determines the status of the churches and other religious societies and their relationship to the state. The relationship between religious communities and the state is very different in the various EU member states, ranging from a state church, for example in England, to laicism in France. In Germany, the religious societies, if firmly organized, can enjoy the status of a public corporation. That means of a public authority. They can even levy taxes. The basis law does not require a strict separation from the state, but shows a general friendly attitude. It even encourages cooperation between the state and the religious societies. This does not only apply to the Christian churches, but also to the Jewish communities, the Orthodox Christian communities, and also to Muslim communities if they are firmly organized. That is the problem with Muslim communities. They need to be organized in some big organizations, which then can be the partner for the state, for corporation. However, thus, the German Basic Law, our constitution, recognizes only the important social function of the religious societies. It does not concede a special role to religion per se. There is no equivalent to Article 29 of the Indonesian Constitution of 1945. Religion or religious values are not constitutional values, even if they may play an important role in the implementation of the constitutional values by the politicians. So, the Basic Law does not allow the state to side ideologically with any confession or religion, or even with religion at all. It insists on the religious philosophical neutrality of the state. This is not different from the situation in most other European Union member states, including France, the laicism. Just Ireland, which has a Christian democratic constitution, is still different. There's another interesting aspect. In a free and democratic constitutional state, the freedom of religion protects the religious latitude of the individual as an essential aspect of his human dignity, but neither serves nor protects religion itself. There is no right to religious activities or symbolism of the state, or to a religion-conform behavior of the state, or to any fostering or shielding of religion against challenges by the state. There can also not be dominance of religion. The state's acting is bound to the constitution, not to the religious values. In particular, in Europe, religion cannot justify any restrictions on fundamental rights, on human rights. This is the same everywhere in Europe. The constitutional order of the state ranks above religion, not religion above the state. What is now the scope of the protection of freedom of religion? Well, it is enjoyed by anyone whose activities serve to cultivate a religion. We have problems with predominantly commercial organizations. Maybe you know the American Scientology Church. Is this just a business or is this a religion? There is another aspect. By the weight virtue of their parental life, combined with their freedom of religion, parents have the right to child education in religious and philosophical respects. However, according to the law on the religious education of children in Germany, this ends when the teenager becomes 14 years old. Then he or she enjoys religious maturity and decides him or herself whether and which religion or religious confession he or she will follow. The child or the teenager of 14 years may abandon the religion in which he was raised, regardless of whether it allows it or not. The religious community and the family must respect his decision, or the authorities must intervene to protect the freedom of the religion of the teenager, even against his parents. This is often a problem in society. For example, we have many very strictly Catholic families where the children become atheists, or we have very strongly Muslim families where the daughter does not follow any Muslim rules. And we also have the opposite. We have families with a Muslim backgrounds which are not religious at all, but their children become Islamists. So it's not up to the parents to decide. Once the children have arrived at the age of 14, then they decide themselves. Now let's come to the materials. What is protected in substance? Well, the faith, the religion, does not need to correspond to any particular religion or kind of religion. So the fundamental rights is not limited to world religions or to monotheist religions or to traditional religions. The religion may be contradictory in itself or appear immoral. It's still free. Even abstruse religious sects, Satanists, and churches preaching free sex enjoy the freedom of religion. Moreover, with regard to the religious philosophical neutrality of the state, a distortion of existing religions, a so-called heresy, enjoys the same protection by the Constitution as the original. We do not make a difference between them. A state intervention to protect the pure belief, for example, the pure Sunni or Shia belief, or the pure Catholic belief, or the pure Christian belief, a state intervention to protect that would be considered a totalitarian approach, more close to Stalinism and Maoism than to the idea of a democratic state. The fundamental right of freedom of religion guarantees the freedom to develop a faith, have a faith, express a faith, and to act in accordance with it, to align one's lifestyle to its rules. This, however, does not require considerateness of the fellow citizens or the state for one's religion. There is also no right to be spared from criticism of one's religion or from any religious forbidden behavior. The free and democratic state respects the freedom of religion, but also requires tolerance from the religious people for any non-religious or anti-religious behavior. Believers who try to impose certain behaviors on others for religious reasons are punished for attempt of coercion under Section 240 of the Criminal Code. The fundamental right also guarantees the negative freedom of the religion. This is the same with all human rights. They do not only guarantee the positive right to do something, but also the negative right not to do something. That means the right not to disclose one's religious beliefs, not to participate in any religious activities, not to have a faith, and not to exercise any religion. This concerns agnostics who do not care whether God exists or not. In the case of atheists, however, it is often not clear if they invoke the negative or the positive freedom of religion. I think that the firm belief that God does not exist, what cannot be proved by evidence, is also a form of faith. So in reality, atheists are believers too. They just believe in the non-existence of God. Concerning the limits, there is a strict decision of the German Constitution, the basic law. So the freedom of religion can only be limited by the so-called inherent limits of fundamental rights. The guarantee itself does not stipulate any limits. This does not mean that the freedom of religion is unlimited, but according to the German doctrine, this means that these fundamental rights are especially important. Freedom of religion can only be restricted if it collides in the individual case with the fundamental rights of other citizens or with other constitutional values. And even then, freedom of religion can only be restricted by virtue of a statutory law, and if in the concrete case, thoroughly weighed, thoroughly balanced, the freedom of religion proves to be subordinate. So it's one of the most protected fundamental rights. However, often there is a collision with the human rights, the fundamental rights of others. For example, the ringing of church bells during the night can be easily banned with regard to the health of the neighbors who need to sleep, the human right to physical integrity. So the freedom of religion does not allow you to ring the bells in the night or the call of the imam in the mosque if it wakes up people and they may suffer from their health. Because then there is a balancing between the health right of the people and the freedom of religion. Now, let's come to some special problems who are vividly discussed in here. The first is that of the crucifix, that means a Christian cross showing the body of Christ in the classroom. This violates the religious philosophical neutrality of the state if, according to the individual circumstances, it gives the impression that the state identifies with the Christian religion. Moreover, a crucifix in the school classroom can violate the negative religious freedom of an atheist and the positive religious freedom of Muslim school students if it is installed in a way that it exerts psychological pressure on the school student. So, however, this pressure effect must be proven in the individual case. For all the special problems which I discuss here, there is one thing you always must need to go into the details. You cannot talk generally about them. The crucifix in the classroom is only prohibited if it raises the impression that the state identifies with the Christian religion. For example, if the crucifix is just mounted at the wall behind the teacher, and if it really does exercise psychological pressure on non-Christian, like Muslim or atheist students. In this case, there is no justification of the encroachment. The educational mandate of the state under its sovereignty of the school does not release the state from its obligation to respect its religious philosophical neutrality. The state is not allowed to do religious indoctrination in any kind of school. This is the same in most European countries. The case, however, is different when the Christian school students themselves place a cross at a place in the classroom where it becomes clear that this is their private expression of their personal belief. So, if it's the Christian students who mount the cross in the classroom, not behind the teacher in a demonstrative way, but somewhere, for example, in the back, and it's clear that this expresses their personal belief, this is covered in Germany by the freedom of religion. However, in the pluralistic society under the German Basic Law, Muslim students may then hang a symbol of Islam, for example, a calligraphy, an image of the Quran or something like that, next to it. And atheist students may then install religious critical symbols next to it. This must be tolerated. There is no privileged position of Christianity or any other religion under the German Basic Law. Now we come to a very controversial topic, the ban on headscarves for teachers in the classroom. It's even very controversial within the Federal Constitutional Court. Is this compatible with the religious philosophical neutrality of the school as a state institution? This is only about state schools, public schools. In 2003, the Federal Constitutional Court declared a ban of the headscarves for teachers admissible, but demanded an explicit legal basis. since the fundamental rights also apply to teachers as public servants. 3 dissenting judges argued in their dissenting opinion that the public servants on duty may invoke the fundamental rights only under certain restrictions, because they have a special relationship of service and loyalty with the state. When the teacher is in the classroom, he cannot exercise his fundamental rights freely, as when he is acting as a private person. In 2015, the Federal Constitutional Court marked a general ban unproportionate and therefore illegal, unconstitutional. If the teacher's behavior was reasonable, traceable to a religious commandment, regarded as obligatory, a headscarf ban would require a sufficiently concrete threat to the school's peace or neutrality. 2 dissenting judges attached more weight to the conflicting values, and they emphasized the legislator's discretion. Well, now it's still under discussion, but in practice, we can say if the personal behavior of the teacher makes clear that she is neutral, she can wear the headscarf in the classroom. But it's still very controversial and different in some levels. In any case, a headscarf ban for teachers in the classroom would need to be directed also against the headscarves of Christian nuns and against Christian crosses if they are worn as a symbol of faith in the classroom. So just a ban of the hijab for teachers in the classroom is not allowed under the freedom of religion. The headscarf ban, the hijab ban for judges, public prosecutors, and legal trainees is, however, justified without any doubts by the constitutionally required strict functional and personal independence and neutrality of the judges. So imagine you have a judge and behind him there is the Christian cross at the wall, or the judge is wearing a hijab, and then you have a fight between maybe a Christian and a Muslim neighbor. How should the citizen believe in the neutrality of the judges? Already the appearance of that the state could not be neutral must be strictly excluded. So if you want to become a judge, a prosecutor, even a legal trainee, no chance to wear a hijab or a Christian cross in the courtroom. The next problem is that of a ban on headscarves for schoolgirls in the classroom. Such a ban would encroach seriously on the schoolgirl's right to align her lifestyle to the rules of her faith, because the school student cannot escape from that. The encroachment in her freedom of religion cannot be justified with regard to the neutrality of the school, because the school student, unlike the teacher, is not part of the school as state institution. She is the user. The teacher or the professor, he is part of the institution. He's representing the state. The school student is the user, the customer of the state. She does not need to be neutral, of course not. Why? However, in school classes with a high proportion of Muslim students, the ban can be justified if it's necessary to protect the freedom of school students which are not willing to wear a headscarf. Students from Muslim families who prefer a Western lifestyle, who understand Islam in a more moderate way, or who simply do not want to follow it, must not be affected in their free decision at the age where they attain religious maturity. They must decide themselves about the role of religion in their life. However, in Germany, according to our experiences, Muslim students are often put under pressure by intolerant Muslim classmates who want to force them. If you are not wearing the hijab, you are a whore, for example. they harass them. And often the headscarf, the hijab in the classroom, serves not only to express their own religiousness, but to intimidate dissenters. So a law could order that a hijab ban may be imposed in schools or school classes where this problem occurs, but it could not ban the headscarf generally. So the situation for a ban on headscarves for teachers is totally different than for a ban on headscarves for the schoolgirls. They are the users, the customers. They are not supposed to be neutral. The ban on the full body veiling in the public is another topic. Several EU member states have imposed that ban. In this case, the ban must concern all kinds of full body veiling, also for non-religious reasons. For example, it must be a ban of masks, of ski masks, of animal costumes, or of helmets with visors in the public, unless there are objective reasons for a different regulation. For example, well, you need to use the helmet with the visor when you are driving on the motorbike. In Austria, they had such a general veiling ban, and it has not affected many burqa or niqab wearers, only very few, but it has shown strange, unexpected side effects for all these people who are wearing masks, animal costumes, helmets without visors, and so on. The freedom of religion in Germany allows a ban on the full body veiling only if it's necessary for the protection of other constitutional values, which have priority in the given context. You can prohibit the niqab or the burqa if it's necessary for the functioning of the schools, for example, in exams or universities or public authorities, integrity of court hearings, and so on. This may be because the citizen must be identifiable. The situation requires open communication with a clear view on the face, for example, when there is an exam, or because the person must be physically agile doing sports. However, what is important? The protection of the German cultural identity cannot justify a ban on the niqab or the burqa, since under the basic law, which is committed to pluralism and builds on tolerance, the national cultural identity is not a constitutional value. You cannot prohibit the burqa or the niqab because you say this is not European style. This is irrelevant. Generally, the protection of public security can justify the niqab or burqa ban because it is necessary for the fight against crime and terrorism, to identify delinquents, for example, by surveillance cameras, to avert terrorist camouflage, and to prevent explosive belts underneath the clothing. We had these cases in France, for example. Men disguised as a woman, as a fat woman with a burqa. In reality, it was men, and they had the bomb under the burqa. So, in the end, it is largely in the discretion of the legislator. Now I come to the last point. Can you still follow? Not too much? This is the question of a ban on cartoons which are critical of religion, the so-called Mohammed cartoons cases. The non-intervention of the public authorities in Europe against the publication of satiric cartoons on the Prophet Muhammad has caused a controversy. Within the limited scope of my lecture here, the German and largely European position can only be presented briefly. It is essential to distinguish three different aspects. If we do not distinguish these three aspects, the discussion is not serious. It's just propaganda. First, the fundamental right to present and publish cartoons including those which depict, that means which show a picture of God or religious leader. The second aspect is the moral question, if such behavior would be appropriate. And the third question is that of the prohibition of cartoons which would insult or degrade the followers of a religion, or which would incite, which would rise hate against them. The first aspect, under the basic law, the freedom of opinion, the freedom of the press, and the freedom of art guarantee the right to present and publish cartoons. This extends to satiric cartoons and even critical cartoons, even if they make fun or criticize an ideology or a religion. From the European perspective, this is very important. This is a basic condition for a democratic state, and the Europeans would never give that up. So nobody can come and prohibit the right to show God on the cartoon or any religious leader, Jesus, Buddha, Muhammad, Vishnu, whoever, on the cartoon. In this context, it is irrelevant if a religion prohibits the pictorial presentation, that means by images, of God or religious leaders. Since in a free and democratic state, it is not the religion which defines the freedom, but its followers must practice tolerance. Otherwise, a country with many religions, confessions, and so on, could end up in a dystopian religious totalitarianism. For the Muslims in Germany, as everywhere in Europe, this means that they may criticize, but must tolerate in the same way cartoons showing God or the Prophet Muhammad, as, for example, atheists and agnostics in Europe who detest religious symbols or behaviors in the public must tolerate Muslima wearing the hijab in the streets. In both cases, in case of threats or violence, the state must intervene against the intolerant because they are the ones who disturb the public order, and not against the citizen who is making use of his or her fundamental rights. This is a decisive element of the European understanding. The state must always intervene against the intolerant, because in a pluralistic society, they may criticize, but they must accept the freedom. However, this does not mean that you should do what you have the right to do. It is a moral imperative in the pluralist society to refrain from presenting or publishing cartoons which would hurt the religious feeling of others. Therefore, responsible media will not republish them. Responsible lecturers will not present such cartoons in their lectures. And friends and colleagues will not show them around, even if they defend the right to do so. You have the right to do so, but the moral obligation not to do so. From the German and the European perspective, morality and law must be strictly separated. The state is not legitimized to enforce morality. This we would call a totalitarian way, like Stalinism or Maoism. But society is. Society can enforce morality. Unethical acting may be sanctioned socially by means such as boycott. You do not buy the journal anymore, which has published cartoons of Muhammad, for example. By dismissal by the employer, the journalist can be kicked out by his boss, or by heavy criticism and even isolation within the group of friends or colleagues, within the professional association, the sports club, the neighborhood, or the family. So if I meet some old uncle who shows me a cartoon of Mohammed in a family meeting, I would attack him very clearly, offensively in the family meeting, and make sure that this is immoral and that he should not do that. This is a common way to react against racism, anti-Semitism, or Islamophobia in Germany. Citizens whose religious feelings have been hurt may ask the society to do so. So, under the German constitutional law, as in the other European states, the Germans have the right to show cartoons of Jesus, Muhammad, whoever, of God, but it may be it may be a moral obligation not to do so. So we would consider this immoral because it would hurt the religious feelings of the Muslims, so we would not do that. And we would sanction them as people who would do that. Moreover, there is, of course, the prohibition of cartoons that are insulting, defamatory, or incite hatred. So, of course, the communicative freedoms, freedom of opinion, of expression, of art, they have their limits in the general laws which protect the public security in Germany and in the right to personal honor. In Germany, as in the other European countries, by the way, including France, which has often been misunderstood in the debate in the Muslim countries, but in all these countries, cartoons and other kinds of expressions are prohibited if they are insulting, if they are defamatory, inflammatory, or if they incite hatred against religious groups. Such cartoons in Germany would fall under the crimes of insult or incitement of masses or revilement of religious faith in communities. And there are similar criminal provisions in other countries, by the way, also in France. When President Macron said we have the right to show cartoons, he did not talk about insulting cartoons, but cartoons in general. Whether there is such a case of insulting, defamatory, or hatred inciting cartoons must not be judged from the perspective of the concerned religion, which usually would be biased, but it must be judged from the perspective of a neutral, objective observer, a judge. So that means it is not possible to consider already the fact of showing God or Prophet Muhammad on the cartoon as insulting or defamatory. No. Moreover, the criminal prohibitions must be interpreted narrowly in the light of the communicative freedom and of their importance for the democratic constitutional order. Yet, even under these criteria, probably some of the controversial cartoons which have been published in Europe have exceeded the limits and have committed crimes. I did not look at these cartoons because I did not want that. I did not want to support those who published these cartoons. I only have seen some cartoons in the context of research in some articles, and according to that, what I have seen, I would say some of the cartoons showing Muhammad, they fall under this. They are just satiric, but just to make a joke, like to make a joke of God or to make a joke of Jesus. This is what we often have in Europe. We have even full movies, cinema movies, who are just a joke about Jesus. Some of them, however, they would fall under this. Some of them, what I have seen, they reminded me very much to anti-Semitic cartoons. That means they showed Muslims or they showed Muhammad like a bad person, like of minor value, and this was clear racism or religious phobism. So that means you need to have a look on the individual cartoon. Anyway, it is not moral to show cartoons if this hurts religious feelings. However, if you act immorally in Europe, you will not be punished by the state or by the judge, the court. You may, however, be punished then by society, by your family, for example, by your girlfriend who may leave you, by your employer who may kick you out from the job, or even by your sports club who may exclude you for your bad behavior. Okay, this is my explanation of this problem. I can tell you that all these problems, these specific problems, are discussed vividly in Europe. Also the last one, there is a lot of discussion in Europe on that. And in Germany, the discussion is just like in the other European countries. Okay, ladies and gentlemen, this is my presentation. In detail, there are some differences in the other European countries, but the general ideas, they are more or less the same. For example, there is no big difference between the situation in France with laicism, in Germany with friendly relationship of churches and religious societies and the state, or in England with a state church. Okay, so I hope that it was not too much. I would like to thank you very much for your attention, and I'm open for any question. The most important is when it comes to these special problems, we must always go into the detail. A general judgment is usually not possible. You cannot say it's allowed to publish a Muhammad cartoon, or the state is allowed to put a crucifix in the school classroom or not. You need to look in the details. How is the cartoon? What kind of cartoon is it? How shall the crucifix be installed? What is the impression it creates? The same for the teachers with headscarves. You cannot make a general rule. Teachers are not allowed to wear a hijab in the school because then they give up neutrality. No, we have lots of teachers who wear the hijab and who make very clearly that they are still neutral. So you always need to go into the details. Okay, thank you very much for your attention.
Okay, thank you, Professor Thomas. That was a very good and clear presentation. So before we move to the question and answer session, I've had several questions, Professor Thomas.
Yeah.
That I will address to you. I have two questions actually. The first one, is there any specific impact for the Germany constitution in relation with the administering the religious matter, since Germany is the member of EU? And then the second one, do you think that it is possible to make a constitution that may drive the people to live each other religion respectively? I mean, like, I refer to the cases in Indonesia where the country is administering the religious matter under the 1945 constitution. However, in fact, it could not be fully applied in my perspective. And I mean, like, there are several blasphemy cases, and yeah, you already live in Indonesia like for almost 2 years, and you know the practice in Indonesia. That is my question, Professor Thomas.
Okay, maybe I answer first, because these are two very interesting and I think important questions. First of all, under the German constitution, there is no administration of religious matters, because religion is not the business of the state, but of society. That is very important. We distinguish state and society. For example, what is the true belief? The state is not allowed even to comment on that. So, because of the religious philosophical neutrality. And in most European countries, it is like that. It is different in Ireland, where the constitution expressly is committed to the Christian values. So this is a little bit similar as in Indonesia, but even it's it's definitely Christian. However, in practice, it's different now. In Ireland, for example, they have gay marriage now, and they have divorce and so on. And if there was a new constitution coming in Ireland, it would not be like that anymore. In all other countries, it's not possible that the state administers any religious matters. What we have in Europe is that the state offers religious classes. They are on a voluntary basis. That means the students who do not want to follow these classes, they can follow a class on ethics and morality without any religious aspect. But that is all. And often it's even the imam from the Muslim communities, or it's the Christian priests who give these religious courses. Then the next aspect is religious pluralism. We think it is possible, but it is difficult to live in a pluralist society. You see, in the past, for example, Muslims in Europe were a small group. And now they are, for example, in Germany, maybe 4 or 5% of the population. And now religious pluralism means something totally different. However, in all the constitution of the free and democratic states in Europe, this is the rule. And the state, if necessary, needs to enforce it. We sometimes have problems. For example, yes, it does happen that the police may need to protect a Muslim mosque or a Jewish synagogue against right-wing radical Germans who think we do not tolerate that. But then the state must intervene. And it happens, I'm sorry, it happens quite often in Europe now, because we have these right-wing groups which would want to have a homogeneous society. But this is not possible anymore. So I think that a constitution can organize that. However, in this case, you need to have a superior value. And for us, the human rights and the freedom are the superior value. If you read this Article 2 of the EU Treaty, which I have put on my paper in footnote 4 on page 2, this is like a credo. You see, the way this clause is formulated, which stresses rule of law, human dignity, human rights for every way, this is almost like a religious way. So in Europe, the superior values are those of human dignity and human rights. And then you can manage it. I think that it is possible. However, it is always in every country difficult to convince old thinking parts of the society. By the way, if I may explain that, the right-wing groups in Europe, the Islamophobic groups, they are not thinking maybe like Prabowo or Jokowi here. They are thinking like maybe like FBI. So in reality, these right-wing groups which want to eliminate pluralism from Europe and which are Islamophobic, they have more or less the same thinking as the FBI in Indonesia. It's the same kind of intolerance.
Okay, so it happens like in every country who administering the religious matter under the constitution. The case in Indonesia, I mean, like that. Okay.
We think that this approach is dangerous. We think that this approach is dangerous. If the state tries to administer a religious matter, it will be involved in conflicts. So I think this is not a good approach, and it brings the state into a difficult situation.
Okay. So anyone who had a question for Professor Thomas, you can either directly ask Professor Thomas or write down your question on the chat box. Actually, we've had one question, Professor Thomas, from Akbar.
Yes.
He is international undergraduate program, a student at Diponegoro University. And his question is like this. What is your opinion if any country which didn't ban a film or cartoon that has a critical for any religion due to state political interests, such as in Indonesia, we're still showing the bad thing about communism, since Indonesia is banning the communism ideology. That is his question.
Yeah. Well, I can say that it is not a good idea to ban a film or cartoon because it is critical of religion, because this simply means that there is no freedom. So, but this is a little bit the case in Indonesia, in particular with the strict blasphemy laws and, as I think, the wrong decisions of the Indonesian Constitutional Court on these laws. I have worked as a lecturer in communist Vietnam some years ago, and I can tell you that now, under the rule of the Communist Party in Vietnam, the freedom for the individual, including for the religious people, is bigger than in the democratic Indonesia. Because there they simply follow now, not in the past. Now they follow the line, for religion is free, but they simply must not intervene into state affairs, and then they are free, and that's it. So if you prohibit expressions, articles, movies, cartoons which are criticizing religion, there cannot be a democracy. So democracy means that all the currents in the society must have the possibility to present themselves and to evolve. So I think from our Western European experience and perspective, this would be incompatible with the very idea of freedom, and that means also with the very idea of human rights. Except, however, if this criticism of the religion is presented in an insulting way, in a defamatory way, or in a way rising hate. So this is not easy for the lawyers, for example, with cartoons. They must say these cartoons are legitimate and these cartoons are not anymore. So in a free and democratic society, everybody is allowed to criticize everything and everybody. I'm even allowed to criticize God if I want and say God is stupid. I can say that, but you are not allowed to any criticism which is an attack on the human rights of other human beings. So this is the limit. Does this answer your question?
Okay, that's a good answer, Professor Thomas. And then we move to other question from Norma. Her question is, currently we are facing a conflict in the Middle East, and it causes large number of Islamic refugees move to Germany and other European states. And her question is, what are the challenges and impact on Germany's law on religion for those that settle in Germany as a new citizen?
That's also a very, very interesting question. Yes, it is a challenge. It depends on the people. What all these refugees who come from a different cultural background, what they must accept when they live in Europe, not only in Germany, the same everywhere, they must accept the pluralism and the freedom in Europe, and also the human rights. And this is a problem for some of them. For example, that the woman is not following the man, the boyfriend or the husband, that the children, when they are 14 years old, they are not following their parents. It is sometimes a problem. Also for the refugees, it depends on that. We have a lot of refugees from Syria, the first wave, which were very smart. They were intellectuals, university lecturers, engineers, teachers and so on, they do not have much problems. But there are also refugees from Muslim countries who come from countryside. So, and also from African countries. It's not only with Muslims, it's with all. They have problems sometimes to accept, for example, that men and women are equal in the German society. So if they come to that other culture and they want to live there, they must accept it. For example, it is not allowed to make hate speech in the mosque against the free and democratic constitutional state. Any attempts to fight the free democracy and to overthrow it are prohibited. And that doesn't make a difference if this is a fascist group, a communist group, or an Islamist or a fundamentalist Christian groups. So some have problems, but they need to adapt on that, otherwise they cannot settle in Germany as a new citizen. On the other hand, the German society and the European societies, they must accept that they have other peoples with other religions and also with other cultural views in their society now. So I would say it's also a problem for some not so educated, traditionally thinking German citizens, in particular in East Germany, where you have many atheists, maybe the majority of the people is atheists in East Germany, and then there is the religious Muslim girl coming with a hijab. But of course, she is allowed to do so, and they must accept that too. So to live with tolerance in a pluralistic society is not easy. I can tell you that. So we have questions everywhere. That is not only in Indonesia, you also have that in Europe.
Okay, that is very interesting. Actually, I had a question regarding following that last question. Is it possible that Germany as a nation to close the border for the immigrant, like for the refugee from the conflict zone? I mean, like, we can say that the refugee will always brings their own like ideology or religion belief or culture, and it may change the situation in Germany, maybe like in some particular aspects or in common aspects.
Well, first of all, in Germany, we have a right to asylum, but this is only for political refugees who are politically persecuted in their country. This is not for war refugees. War refugees, like those from Syria, for example, they are only admitted under the Geneva Convention. That means if they are not really in personal danger, they can be kicked out. It's not a problem. So Germany can restrict the access to those who are really real war refugees, and also to those who are asking for political asylum. The high number of refugees is based on the fact that Germany is still willing to accept them. Usually, in most cases, Germany would not need to accept them, because in Europe and the European Union, we have the rule that they must stay in the first European country where they arrive. And most of them, they enter via Greece or via Bulgaria or Romania, so they must stay in Greece. There is no human right for the refugee to choose the European member state where he wants to live. The right to asylum and the right to refugium serves to protect your life, to protect your security. And in poor Bulgaria and in poor Greece, you are safe in the same way as in Germany. And that means that Germany could close the borders more. The Danish people are doing that. They want now to bring all refugees outside the European Union. That means they want to make an agreement with, for example, Arabian countries, where they can bring all Muslim refugees, and then during the asylum procedure, these refugees are not allowed to stay in Denmark, but they will stay in this other country, which is, however, safe. If this will work, I don't know, but the problem is mainly a homemade problem. It's not the problem of the refugees. It's the problem of insufficient acting. Authorities with not enough civil servants deciding, not enough courts, not enough judges to decide on these cases, and so on. So I think that, yes, Germany could restrict a little bit. It could, however, never totally exclude, for example, Muslim refugees. No way. Under the German constitution, this is not possible.
Okay, thank you for your answer, Professor Thomas. We've had another question. It is from Efrema. She is one of the IUP law student here at Fakultas Hukum Universitas Diponegoro. And her question is, what if a movie depicts a religious story exactly how its respective religious sources describe it, meaning it has no intention in offending anyone, yet it still offends the majority of the people practicing the religion? Should the state follow the majority or keep the rights of the freedom of the production of the movie?
Yes, thank you for this clarifying question, Efrema. This is very clear, my answer. The state must keep the rights of the freedom of the production of the movie. So if the majority of the people follow a religion and they don't like that, this is totally irrelevant. The religion of the majority of the people is totally irrelevant in a free and democratic state. So for the constitution, the state must fight against any kind of intolerance. And it doesn't matter if the intolerant are just a group of 5 people or 5 million people. In the worst case, the state may even need to use violence against the intolerant. So it's very clear that under our concept of the free and democratic state, in Germany as in the other countries, it's the majority is not decisive. It doesn't matter what are the religious feelings of the majority. Simply doesn't matter. It's the freedom of the individual which matters. Does this answer your question?
Okay. Okay. Thank you, Professor Thomas. So for other participants, you may directly ask Professor Thomas, or you may write down.
There is still one, I see.
Yeah. You had one question, Professor Thomas, from Hansa. From Hansa, and she had 2 questions. The first one, would you think that the regulation on religious blasphemy is a suitable response in creating the so-called religious harmony, or it is a blatant restriction on freedom of opinion or expression, since the European Court of Human Rights also had different opinions in addressing religious blasphemy cases? And then the second question is, what is your opinion on the rapid plan of action that promotes the ban on religious incitement rather than blasphemy, and its changes in redefining or reconstructing the blasphemy law?
Okay, let me start with the first question. Personally, I am against any blasphemy laws. Blasphemy laws are an act of totalitarianism. You cannot have democracy and freedom and blasphemy laws, because the problem is how you handle them. And even if you have a blasphemy law, you must handle them in a restrictive way, because otherwise there will be no freedom at all. So the blasphemy laws exist still in Europe. They are controversial. Most of the constitutionalists are asking to abolish them. But in practice, the blasphemy laws are interpreted in a very, very narrow way. That means only if it is compatible with the respect of the freedom of expression is it allowed to apply the blasphemy laws. And in most cases, it is not. So when you see, for example, the judgments of the Indonesian Constitutional Court, they totally ignore the really relevant aspects. This means you cannot punish somebody for blasphemy because a majority of religious people in the society is upset and they start riots. The state must fight against the intolerant and not against those who use their freedom of expression. And blasphemy laws is mainly an instrument of a totalitarian regime. I would say that quite clearly, except if it is redefined, not in the Indonesian way, if it is redefined in a very restricted way, and it only covers cases where the blasphemy is raising hate against religious people, or is defamating and so on. What in any case is not possible is that a blasphemy protects a religion against heresy. This is Stalinism. Sorry, but this is the same. This is a totalitarian approach. The state does not have the right to protect a religion against heresy. This is the question of the society. So personally, I'm in favor of replacing the blasphemy laws by new laws. We have this in Germany. You can click on the link on my paper, where it's very clear that only attacks on a religion which violate the human rights of the religious followers in a specific way, they can be punished. So concerning that second question, I do not know that Robert's plan of action, I'm sorry, but the idea of redefining these articles is important for me. I think that the blasphemy laws should be simply abolished, and they should be replaced by laws which define as a crime if you incite hate against, not a religious person. One thing too, there is no legitimacy of the state from our German and European perspective to protect religion. This must be clear. Religion must not be protected by the state. This is against freedom. So, and against democracy. So the function of any criminal law is to protect the followers of a religion against hate, against violent attacks, against intolerance, against defamation, and so on, but never to protect the religion itself. Religion itself is not a value for the constitution. It's your personal value. Yes, in society it can be a value.
So protect the people, right?
Protect the people, but not the religion.
Okay.
But I need to add one thing. I told you about the moral sanctions. So society can take sanctions differently. For example, the parents, they can disinherit the child which criticizes their religion. They say, we will exclude you from inheriting my money when I die. That, for example, a family can exclude, or a very religious wife, she can divorce from her husband if her husband insults the religion. This is a sanction in society. This is up to them. For example, there are parents in Germany where who say the Muslim parents, and the girl has a boyfriend. Of course, she has sex when she's 16, 17 years old, as it is normal in Germany, and she does not wear a hijab. And then they say, we will exclude you from our family. You will not get anything of our family assets when we die. This is, of course, maybe not nice. Personally, I would not consider this correct. No, don't misunderstand me. I do not consider this correct, but that is their freedom. So also a group of friends, they can exclude somebody. If somebody in a group of friends, well, if a friend of mine, for example, shows a cartoon of Muhammad, I will not invite him to my next party. That I will say I will not do that because of this reason. These are the sanctions of society, and they play a role. They play a role, for example, to expel Islamophobists or anti-Semites from sports club, for example. They are kicked out of the gym, or they are kicked out of the football club. It happens already there. So, for example, but not the law, not under the law. Okay?
Okay. That's quite clear, Professor. That's actually very clear. Okay. Another question from Rosemary, international undergraduate program students. Her question is like this. in Indonesia, there is a case about one of the public school, not an Islamic school, that forced the student to use hijab, no matter what their religion is. What is your opinion about that situation, and how can we prevent that thing to happen if it is already become the unwritten norm?
Yeah.
It is quite hard if it is already forming into a norm. Thank you, Professor.
Yeah. Okay, first of all, now I may remind you this practice is excluded. The government has taken a regulation which prohibits this practice. And the government regulation is above any customary norm. So in Indonesia. So now this practice is not allowed on schools, and it's not a single case. I have heard these stories from colleagues of mine where the school wanted to force the Christian daughter to wear a hijab. This is a clear violation of the human rights. So of the free personal development of the schoolgirls. No school is allowed to force somebody to follow religious symbols. That is absolutely clear. My proposal would be to make a crime of that. So my proposal for Indonesia would be to introduce a new crime into the criminal court, which is called religious intolerance. I think this is what Indonesia needs, a criminal provision which says whoever tries to force somebody to do something or not to do something just because of religious reasons will be punished by prison. So we have this as for all kinds of forcing. If you try to force somebody to do something you're not allowed, it's a coercion under section 240 of the German Criminal Code. And I think in Indonesia you wouldn't need such a clause.
Oh,
so they also, yeah, yes?
Yeah, Germany have that type of law.
Well, we have a criminal provision which says whenever you force somebody to do something and you are not legally entitled to do so, but you force him by threatening him or by abusing also your position, then you can be punished. And this includes also for political reasons, this includes everything. So this would be a clear case if the head of a public institutions, like, of course, only government schools, like a government school, if they try to force a non-Muslim girl to wear a hijab, I think they should go to prison for that. This would be my solution for lots of cases like that.
Okay. What a idea. This is my first time hear that kind of idea, and that is
Yeah.
a good idea actually.
Yeah, of course.
That is my first time hearing that.
You need to be very careful when you define that norm. So you need to think a lot, how would you define such a norm? But I think this would be the right way. I think religious intolerance, also when you have mobs of neighbors who come to stop people from doing something because the neighbors think this does not comply with their morality. So for religious reasons, I think this should be considered a crime. Defined as a crime in the criminal.
Okay. Thank you for the answer, Professor. And now we move for the last question, maybe from Norma. Again, from Norma. Her question is: the freedom of religion are very important, and it can only be restricted. It can only be restricted in the event of a collision with fundamental rights of other citizens or other constitutional values. If other fundamental rights are prioritized and the freedom of religion proves to be subordinate under the Constitution, would this imply a hierarchy between other fundamental rights and the freedom of religion?
This is also a good question. I need to go a little bit deeper into fundamental rights doctrine. In Germany, all the fundamental rights have specific limitation clauses. that means the limits of the fundamental rights are different. This is the case in most European countries. So, and for some fundamental rights, the limits are stricter, and for others, they are not so strict. This means there is some kind of informal hierarchy. That means when the pouvoir constituant, the constitution maker, when they make the constitution, they evaluate a little bit the importance of fundamental rights. So according to this practice, which is widespread in Europe, also in the European Convention, that every fundamental right has specific limitations. In Germany, the freedom of religion is generally higher than many other fundamental rights because there is no specific clause, it's only the inherent limits which always exist. However, the same applies, for example, for the freedom of arts under the German constitution. So you have often several rights which are higher, but for example, we have a general freedom of action to do whatever you want to do or not to do. And this freedom has very tough restrictions, so it's lower in the hierarchy. We could say that. However, what is decisive is how you balance this in the individual case. That means it also is important how deep is the restrictions of that other fundamental right or the threat to this other fundamental right, and how deep would be the restriction of your own fundamental right. So you need also to consider the situation. For example, we do not allow the church to ring the bell in the night, or the imam to call from the mosque to call for the prayer in the night, because this would violate health. So the right to health and physical integrity. But also, it's not that we say generally the health is more important, no. But we know that the call every night in the night would be a big health problem for many citizens in Germany. On the other hand, the Christians or the Muslims who want to go to the church or to a mosque in the night, they can download an app on their smartphone and let the smartphone wake them up. So the function of the call, just to remind you that you should go to the mosque or to the church in the night, this can be performed in another way. So there is no reason. So the restriction of the freedom of religion is not severe. It's not a big restriction of the freedom of religion if you're not allowed to call or to ring the bell in the night. In this case, we say, okay, then the health of the people is more important. However, there are other cases where the balancing can be very, very difficult. Okay, usually it depends on all the circumstances in the individual case.
Okay. Thank you for your answer, Professor Thomas. And then last question. Actually, there are several questions that I think that the what is already answered by your presentation. And the question is from Raisa Zandra. Her question is like this. In your opinion, should religion be exempt from satire since it would offend religious community? Regarding the cartoon and movie, Professor.
No, generally speaking, I would say no, because religion is just one factor in society. It's taken very, very seriously in Indonesia, but in other societies not. Other people, for example, they feel more insulted if the ethnic background plays a role in the satiric, or if political ideas play a role in the satiric, or if certain professions they would like to be then exempted from satire. So I think nothing should be exempted from satire. The idea to have freedom of expression, freedom of art, means that nothing should generally be exempted from satire. but everything should be exempted when it violates the human rights of others. And this needs to be defined narrowly, and this is difficult. I understand that, but I'm not in favor of exempting whole parts of society like religion or certain professions. Then the next step would be that the president says, okay, the president should be exempt from satire, or maybe the parliament should be exempt from satire. So this would not be the right approach, I think. It would be dangerous.
Okay, okay. Thank you for your answer, Professor Thomas. And we've already reached our last part.
One question. There's still one question. I can shortly answer.
Okay.
To that.
Okay.
About interfaith marriage. Of course, the prohibition of interfaith marriage is incompatible with human dignity. So this is not so much about freedom of religion, but about the free development and the freedom to marriage. So in Europe and all the countries where we have the fundamental right, the human right to marry. And of course, there cannot be any prohibition of interfaith marriage. From our Western perspective, this is incompatible with the idea of human rights. By the way, you know that I have heard that in Indonesia, many couples, then they go to another country and they marry there if they have different religions, and then they come back. Is this correct?
Yeah. Sometimes they go to other country to get married, and then they go back to Indonesia, and then they can happily live their marriage after.
Then it's a minor problem. That makes a big difference. If the state says, I will not do that, but you can do that abroad. In modern society, everybody can travel abroad, and then they can do that somewhere else.
Mm-hmm.
Still, of course, for example, for those who do not have the financial means to travel abroad, it may be a problem. So still, I think it is still a violation of human rights, but not so serious.
Okay. Thank you for your answer, Professor Thomas. What a discussion today. And maybe you have a bit of closing statement, Professor Thomas.
Thank you very much for inviting me, and also for the very interesting questions here. So maybe, if somebody wants to tell your opinion about these problems, you can also do, would also be interesting. Anyway, it was very interesting for me also to see the questions arising. So anybody who has more questions can contact me via email. The email address is on my paper or on my website. And I hope that I will have the possibility to visit Universitas Diponegoro, maybe to give another lecture in the future back in classroom. So this is very important. The freedom of religion and tolerance in a pluralistic society is a topic issue. And you can see not only in Indonesia, not only in the Muslim countries, in all the European countries, in North America. This is also a little bit due to globalization. Due to globalization, people of different cultures, people of different religious backgrounds, they mix more than they did in the past. So I think it will be always important to keep the necessity of tolerance and pluralism in mind. Thank you very much for your attention.
Professor Thomas. Thank you very much for your lecture. We do hope that we can meet you in person in a very short time, once the pandemic's over. Thank you once again, Professor Thomas Schmitz, for giving your lecture. And I'll give the time back to you, Daniel.
Thank you very much, Mr. Diastama and Professor Thomas, for the wonderful discussion. Ladies and gentlemen, now we will hold a short photo session. We welcome all of the participants So please turn on your cameras and take position. The photo will be taken on my signal. Please turn on your cameras.
It may not be possible for everybody. I have this problem in all my lectures.
Yes, anyone is turning off the camera, Professor.
Yes. And this problem is discussed in Germany too. That's it.
Okay, I think we will take the picture now. Everyone smile. 1, 2, 3. One more. 1, 2, 3. Thank you very much, ladies and gentlemen. We have finally come to the end of our session. It has been a great and wonderful morning with all of you. Thank you very much for your participation and attention.
Thank you, Professor Thomas. See you soon.
Thank you.
Thank you, Professor
See you
Thomas.
soon. Sampai jumpa.
Terima
Sampai
kasih.
jumpa, Professor Thomas. Terima kasih.